Even though he's touted himself as the most pro-union president in American history, that vision hasn't filtered down into federal agencies in the way that we would have liked to have seen.
Which side are you on? Which side are you on?
We are going to be talking about the new contract negotiated by the American Federation of Government Employees and the Social Security Administration, which is going to cover 42,000 Social Security employees nationwide. And these new workplace rights and protections, they are really, really, really cool. Just a couple of them here. You know, there's going to be new allowances for temporary compassionate assignments for a temporary personal situation outside of their control, like illness of a parent. I know this is something that my family's actually going through right now. My grandmother had a stroke, or had 2 strokes now. And so we're having to care for her. And you know, it's been like difficult on our family that has to work. And so being able to kind of change your situation at work for a while, really, I can personally now understand how beneficial that's going to be to these members. There's going to be more funds for emergency backup care. There's going to be more protections for mothers who need to breastfeed. Lots of cool stuff. We're going to dig into it a little bit more with Rich Couture. He is the president of the AFGE Council 220, which represents Social Security Administration workers. Rich, thanks for talking to us on the program today.
Hey, thanks for having me. And, best wishes to you and your family and your grandmother for a speedy recovery.
I appreciate it. I really do. So, yeah, before we jump into this contract, I guess, can you talk to us about what the employees that you represent do? Because, I think that there's a lot of people there's just, for anything in our society, actually, if you've never actually done the work or you've never watched people do the work, you can't appreciate how much work goes into certain things. And one example that I've been pointing to lately for that is shows like concerts and stuff. The Stagehands Union in Huntsville, they're the exclusive labor provider for the Orion Amphitheater and the VBC. We have a bunch of big concerts, and and I was able to go through a walkthrough with the union as they were setting up for a Fish concert one time. And there was, like 50, 60, 70 people running around a day or two before the concert even began. It's amazing how much work goes into stuff like that. And so I'm positive that there's a similar situation going on in the Social Security Administration. Can you talk to us about what your members do?
Sure. So, we have a very diverse agency, both demographically speaking and also in the nature of the work that we perform. And so, my folks, I'm actually president of Council 215, 215. And my particular part of the agency represents employees in our hearing offices and our appeals council installations nationwide. And so by the time my constituents get involved in the claims process would be after the initial 2 steps of disability claims primarily, where they would go through the field office employees who are represented by Council 220. They would, file their disability applications. There'd be a disability determination made on those claims. And if they happen to be denied or they disagree with the decision in any way at the first 2 steps, the initial step and the reconsideration step, then they have the right under the law to a hearing before an administrative law judge of Social Security. And so my colleagues in the hearing offices, we are the support staff for those ALJs. So we'll do all the case workup before the hearing. We'll assist in scheduling the hearing, review the cases for the judge prior to the hearing, and then draft a decision for the judge after the hearing, along with other sort of post-hearing workloads. And so that's who I represent. Now, I touched upon the field offices. They're the primary point of contact, or one of the 2 main primary points of contact that the American public would have with Social Security. Everything from getting a Social Security card taken care of, to filing a retirement, a survivors, a disability application with a claims specialist, dealing with representative payee issues when somebody's not capable of handling their own funds and they need a responsible family member or other third party to manage their benefits for them. All of that type of work is addressed at the field office. And so there's about over 1,200 field offices nationwide. And so that is, again, one of the two main points of contact that virtually every American would have with this agency. The other being our 800 number, our teleservice centers. You call our 800 number, you're going to be talking to one of our bargaining unit employees who's going to try to assist you. Unfortunately, under some fairly onerous circumstances, given our staffing situation and the expectations that the agency has with production on the calls. So, in addition to that, we have about 8 payment centers nationwide, 2 at headquarters, and then the other 6 all over the country that are represented by Council 109 and Local 1923 in Baltimore, a data operations center in Wilkes-Barre, Pennsylvania, and then quality review offices located in the regional offices nationwide. So we have we're all over the country. As you noted, we're over 42,000 bargaining unit employees strong. And, the nature of the work that we do is, again, very diverse, as is our workforce.
Right. And so you were the chief negotiator for this round of negotiations. What were some of what were your biggest priorities, the things that you wanted to accomplish for your members going into these negotiations?
So I think for your benefit and the benefit of the listeners, I want to back up to 2018 because that's when all the fun started. And I'm being sarcastic in saying it was fun. Memorial Day weekend. So our contract, our 2012 national agreement expired in December of 2017, and the agency under the last administration had signaled to us that they were very interested in reopening the contract and going through full-term negotiations. And, we began preparing for those negotiations almost as if we were under normal circumstances. Memorial Day weekend 2018, the last administration had issued 3 anti-union, anti-employee executive orders that were geared towards curtailing, if not outright gutting, the rights of federal employees to have union representation, effective union representation, as well as certain due process and procedural rights that they would have with respect to issues such as, performance cases and disciplinary matters. And so we saw this as an outright attack on our existence as federal sector labor organizations and, on very, very dearly held rights that we have as federal employees. To representation in the workplace and to some basic fundamental due process in the way that management addresses alleged performance issues and disciplinary problems. And so, we had to retool and really try to address this fundamental attack, almost as if we were building the plane in midair. The agency came in, SSA came in very hot. Their proposals were some of the most draconian rollbacks of these rights that I've ever seen. I mean, under normal circumstances, management is keen to, make proposals out of left field to try to, curtail these sorts of rights, but they aren't truly serious proposals under normal circumstances. The agency's initial proposals with respect to representational time, with respect to performance, with respect to discipline, with respect to access to union representatives on site during the workday, were some of the most egregious proposals I had ever seen. I mean, they were akin to science fiction, and not good science fiction like Star Trek. So, they wanted a truncated negotiation schedule of only 4 months, where we would meet 2 weeks a month for the course of 4 months. And then if we did not reach an agreement by that point, as you know, or you may be aware, federal employees are not allowed to strike. PATCO, we're governed by the same law that Reagan used to wipe out PATCO. And so we're not allowed to strike. And when we reach a bargaining impasse, our employer can't lock us out and we can't withhold our labor. And so a third-party panel of 7 individuals that is selected entirely by the president and is not subject to, to my, as I speak right now, to my knowledge, not subject necessarily to confirmation. They're allowed to, there's no requirement for partisan or ideological balance. And so what normally happens under a Republican administration is that a Republican president will pick management-friendly panel members. And in a Democratic administration, because the Democrats like fairness, they'll try to strive for some type of balance between the two poles. And
isn't that funny? I just want to just take a second to think about that, because this happens all the time. When Democrats get in, they try to do this like, oh, we want to appear fair and balanced and not too, we don't want to be too pro-worker, right? And so they'll appoint bosses and workers, whereas Republicans will they'll just do management side people. I mean, that's just, it's a funny kind of lack of symmetry.
I agree, 100%. And the GOP generally looks at these situations and say we're going to do what we want because we won.
Right.
Right. We feel we have a mandate, and there isn't that symmetry or that that there isn't a reciprocal offsetting sentiment by the Democratic Party when they get into power. Although the current impasses panel is better than most. However, my general feeling is the impasses panel is not necessarily the place that a federal sector union goes for justice. And what the Trump administration had done was it was management friendly on steroids. They had picked not just management friendly, law professors or management side labor attorneys. They picked union busters. It was the most hostile panel that we had ever seen. And so, under these circumstances where they immediately gutted our representational time, immediately removed our ability to access employees at the work site through these executive orders, unilaterally rewrote parts of our prior term agreement because it had expired and they felt they had the right to do so. We were then going into negotiations with both hands tied behind our back, and it really revealed, not just to those of us at Social Security, but also I think the federal sector, the labor movement in general, just how vulnerable we were politically and legally to a change in administration, and particularly to an administration that was hostile to the very existence of federal sector union rights. And so where we ended up going was, trying to preserve as much as we could. It certainly wasn't a situation where, the entire federal sector labor relations apparatus was arrayed against us. And what I mean by that was, and I just kind of went into the Federal Service Impasses panel that would break the bargaining impasse, but the Federal Labor Relations Authority, or FLRA, which is the federal sector analog to the National Labor Relations Board, there was a 2 Republican, 1 Democrat composition. So obviously it was an anti-worker majority, but they curiously had no general counsel. And under their interpretation of their internal rules and regulations, they felt that if they didn't have a confirmed or proper general counsel in place, they were not in a position to issue complaints in unfair labor practice charges. And so we had an entire venue shut down to us. And so we couldn't go to the FLRA for justice. The panel certainly was not a place where we could go for justice. And so, my union at the national level, other federal sector unions had filed lawsuits against the executive orders that resulted in late August of 2018, an injunction against any action taken by subordinates of the president, i.e. federal agencies, to take any steps to implement the more draconian provisions of those executive orders. And interestingly enough, the judge in that case is now Justice Brown Jackson on the Supreme Court. So, we went through this very rapid fire negotiation process in 2018 and into 2019, where, the agency was taking this very scattershot approach to negotiations because they wanted to be able to say with a straight face, we talked about all the contract articles, therefore, and we're not getting an agreement, therefore we need to be released to go to the impasses panel. And ultimately, that's what happened in December of 2018 and into January of 2019. We found ourselves in front of this hostile impasses panel that did follow through on the threats made by the administration, the last administration. We found our representational time cut and gutted. We found ourselves removed from federal office work sites in terms of union offices and the like. Performance rights we were able to hold on to some degree. They wanted to, what the agency and the administration wanted to do at that time was foreclose the grievance procedure and the arbitration process to performance cases and severe disciplinary cases. They wanted everything to go to what's called the Merit Systems Protection Board, which is, again, not a very, it's not known for being an employee-friendly body. It's highly legalistic. It's not the less formal environment that you would see in a grievance procedure. And we were fortunately able to hold on to those rights because there was very clear precedent in the DC circuit that if you're going to try to take those rights away and avoid having a broad scope grievance process, that you have to have a good, solid business justification for doing so. And, our argument was SSA can't make that case. They've never even proffered any evidence to that point. And so it was one of the few things that we were able to hold on to in that environment. But we found our telework rights were eliminated. And as I said, they made our ability to represent our workforce tremendously harder as a result of the executive orders and the bargaining posture. And so why I wanted to get into all that background is because you asked about our priorities. We have been clawing back, almost negotiating or renegotiating this term agreement in a piecemeal fashion through settlement of litigation, which we got to restore our prior representational rights under the last agreement, and then to renegotiate parts of the contract that really went to very important issues involving employee rights and work-life balance and those sorts of things, as well as trying to find a way to better work with agency executives to simply get things done, both to improve working conditions and improve public service outside of the context of the traditional collective bargaining system, which even under President Biden has not been the easiest road to travel. And we're not the only agency that's been in that boat. It has been fairly universal across the federal government and other federal agencies that even though President Biden has referred to himself as the most pro-union president in American history, I think FDR might have a better claim to that, such as it is. But, even though he's touted himself as the most pro-union president in American history, that feeling, that sentiment, that vision hasn't filtered down into federal agencies in the way that we would have liked to have seen. Especially since he rescinded the Trump orders within the first 48 hours of his administration.
Hey, 5 seconds. Just wanted to say that this is only possible because of our donors. If you want to see more of this, then consider donating yourself at tvlr.fm/donate.
Again, brother, I could not agree with you more. That's just another kind of asymmetry that you see, because like as soon as Republicans get in office, they try to do everything that they can to take away worker power within the federal service, and it's just, and part of it is that it's just kind of difficult to it is difficult to rebuild. Like it's easy to knock stuff down, right? But it kind of takes a little bit more time to rebuild, and so that's one reason. But I do think there's just a lack of urgency with this. Allowing the NLRB to continue to not be funded properly through the Biden administration. They got a 10% increase in the last fiscal year, which only kept up with inflation. Right. I mean, and that's after they had been flat funded since 2014. I mean, it's just there's a whole lot more that I think that we could be getting and that federal workers deserve, and that, like you said, would be to the benefit of the people, the American public that we serve. Because when you have workers that are taken care of, that are comfortable, that can have a good middle-class life and be secure in their jobs, they're going to be able to perform better. And we saw that over the pandemic with UPS. I mean, it was just a perfect example of, okay, here's a test. FedEx and UPS, they are both strained by the pandemic because of the increase in volume that they have to, that they're being asked to transport. FedEx repeatedly failed. Their late deliveries were far more than UPS, and they made significantly less profit because less people wanted to go to FedEx because they knew that UPS was going to get it to them on time more often, and UPS was better able to retain employees and better able to take advantage of that environment where there is more volume, and so they made significantly more profits than FedEx did over the pandemic because of their workforce that was relatively well taken care of. Of course, there were a lot of issues, and a lot of those issues were addressed with this new tentative agreement. I think there's still more that some employees at UPS want, but it's a big step forward. And so that's a great point that you brought up about how, it's not as if the interests of us as federal employees. I'm not sure if you knew, or if Michael told you that I'm a member of AFGE Local 1858. Our interests are not in competition with the American public that we serve. It's actually, we're aligned. So that's a great point. And so with that, what were some of the things that y'all were able to win in this contract?
So let me just say, you're absolutely quite right about happy employees. They're more productive, morale's higher. You're looking at better retention of employees, and it's really that I'm going to use that as the jumping off point for what we wanted to do, what we wanted to accomplish through the negotiations. SSA during the pandemic, in a lot of ways, I already used the metaphor of building the plane in midair, and that really was something that we were doing at SSA. For the 2 years that we were out due to COVID-19, we had gone from a scenario in which the last Republican commissioner had wiped out telework for our field offices, our 800 number, and our payment centers, among other places, and had curtailed telework for a lot of other support staff, such as in the hearing offices, headquarters, regional offices, et cetera. And we immediately, it was whiplash. We went from having these cuts and eliminations to all of a sudden going into a mandatory evacuation posture where everybody who could work remotely was working remotely, which was, upwards of 95% of the bargaining unit. Field office employees who traditionally, obviously working in the office most days, if not every day, were now working from home 100% of the time and trying to find, as with everybody else in the agency. And so it was this major culture shift where the agency had to acknowledge, for example, that we could do our work differently, and we needed to modernize our approach to public service. The people I represent, and I trust you're of like mind since you mentioned you're a fellow federal employee. We're mission minded. When I joined SSA in 2002, I did it because I wanted to serve my country. I wanted to give back to my community. That's how I was inclined. It wasn't just a job. I knew I wanted to serve the public.
So,
And-
Rich, you mean to tell me you didn't join you didn't work for the federal government because you wanted to get rich?
Yeah, you caught me. I think it was it's something that JFK said about, you should be, federal employees should be comfortable knowing that they're not going to get rich serving the public, but they should be able to have a good life. And really that's what we need to strive for. I mean, and then certainly not just federal employees, but workers in general. And there's, so this whole pandemic mind shift, the shift in the way that we did our work, it really helped save the agency because we were having hiring problems. We were having problems with adequate staffing, which led to service degradation. And the telework posture, this full telework posture, really helped keep people employed and serving the public, even under very exigent circumstances. And it really helped the agency hold on. When we started returning to the offices in late March 2022, we started seeing a precipitous drop in the bargaining unit size. We saw a lot of retirements, a lot of separations, and we knew of a lot of folks who were leaving either for other federal agencies where the working conditions were better, where the benefits were better. The micromanagement wasn't as existent as it is and prevalent as it is at SSA, particularly in the field offices and the hearing offices and elsewhere. We used to be a receiver agency. Like, we would attract employees from the VA, from the IRS, from the Department of Labor, and now we're a donor agency, and we give to those agencies, among others. And so we started seeing a public service emergency, a real crisis that was being driven by attrition and record levels of attrition. Our 800 numbers saw attrition levels around 20% in a year's time. And so what the agency, what SSA has tried to do, and you're seeing this with, these regressive pieces of legislation out there, like the Show Up Act that the GOP's pushed in the House and is trying to get passed in the Senate, which would require federal employees to basically go back to pre-pandemic levels of telework. Some of the posturing of the Biden administration to try to force employees to go back to the offices in greater numbers. It really, it's things like this that are not congruent with reality. At SSA, we're seeing waiting times on the 800 number rise, and it's not because of telework. It's because we don't have enough people to answer the phone. Waiting times right now are north of 35 minutes and growing. I mean, every time we lose an 800 number worker, that just adds to the wait times because it's one less person to share the workload, which means the public waits longer. And similarly, with staffing declines in the field offices and our workload support units, it just means that people are waiting longer for their claims to be processed to get the money that they've earned, that they deserve by paying into the system. Likewise with the hearing offices, more support staff leave. It takes longer to get a case ready for hearing, get scheduled for hearing, and to have a decision issued. Thus we're making people wait longer to get the money that they're entitled to. And that's not right. And so, as you stated, our interests and the interests of the public are very much aligned. And so what we wanted to do through the limited reopener that we took care of, and the agreement that we reached, the tentative agreement that we reached, was to try to tackle as many of those issues as possible. What's driving attrition? What's making it more difficult for the agency to attract, recruit, and hold on to new workers? In fiscal year 22, we lost almost 17% of our new hires. I mean, these are people who were hired up off the street to go through rigorous training on our very complex programs, and they're not staying. And, that's a problem. And because they look around and they're like, wait a minute, I'm only getting paid this much, and I'm not guaranteed the same type of benefits that I can find in other agencies or other sectors. This isn't what I signed up for, and they leave. And we still see anecdotally, although I'll tell you, as recent as this week, as recent as Tuesday, we were in a meeting with the agency, and we asked for updated attrition figures. And they told us that because those figures aren't yet public, they're not going to share them. So they have them. They're just not going to give them to us. And so, the point that we've been making all along has been, how can we solve problems if we can't even identify and admit to what those problems are? Hiding attrition data isn't going to help serve the public any better. And, maybe it makes the agency look bad, but, sunshine is the best disinfectant. And, having that information out there so we can talk about what those drivers are is critically important to obviously improving working conditions for the employees so that we're dealing with the causes of attrition and the causes of poor recruitment numbers. But we're also ensuring that we are maintaining, to the extent possible, the level of service that the public deserves. So, a lot of our proposals, some of those that you have mentioned, that you had mentioned at the outset of our conversation, such as the temporary compassionate assignments, the improvements in the lactation program, the prospective benefit that we're going to be looking at for emergency dependent care, these improvements in our disciplinary process, improvements in our employee rights article, a lot of these issues, we're going to have for the first time agency-wide a virtual detail program. So we're going to leverage technology to help with career opportunities for employees who oftentimes get stovepiped and are limited by the part of the agency in which they work, and oftentimes the geographical area in which they work. And so this is going to open up a whole world of opportunity for employees to advance themselves in their careers at SSA, give them more opportunities and greater flexibility and work-life balance. And all of that is a net positive. Certainly, there's a lot of other issues, a lot of other things that we want to see have happen. But we are unfortunately constrained by the appropriations process and the arbitrary rules that really stymie the ability of Congress to give SSA the funding it needs to be a premier agency, to be the gold standard for public service in the government. So that was one of the main missions that we had, and recognizing that funding is a problem, and that the agency was very resistant to proposals that would cost money, and recognizing that we've had this problem where the traditional collective bargaining process has not worked in the way that it was designed under federal sector labor law, and certainly the way that we've experienced over the last 20, 30 years, where we can get agreements done fairly quickly. We've been able to do that historically, and now agreements that would take 2-3 days to negotiate, midterm agreements, impact and implementation stuff, that's now taking 2 to 3 weeks or 2 to 3 months, and oftentimes is only after we've filed, grievances or ULP charges for failure to bargain and all the rest to compel the agency to go to the table in the first place. And so what we sought to do, and this is one of the things that President Biden has stated, but has not yet required through any type of executive order. The president has been very keen to see labor leadership and agency leadership across the government to come together and cooperate through a process similar to partnership, which was the term that was used during the Clinton administration that was very, very successful at SSA, and forums under the Obama administration, which was not as robust as, say, the Clinton era partnership, but it still resulted in a lot of good for both the employees and the public. And what this cooperation process that we were successful in negotiating at the table without having the benefit of an executive order to compel SSA to do so, was building a process by which union leaders such as myself and agency executives in the major components, in the Office of Commissioner, if need be, the Office of Human Resources, et cetera, we will meet directly and we will run these meetings jointly, and we will establish these agenda items jointly. And there will be greater openness and transparency with respect to information and with respect to interests to try to solve working condition issues and public service issues on a pre-decisional basis. And so by doing so, neither party is waiving any of their statutory contractual rights, but you remove all of the obstacles that are inherent with the traditional collective bargaining process, such as management rights, and they don't ever want to do anything that violates those. And everything to them is a violation. Everything to them is a violation of management rights. So those sorts of obstacles aren't present because technically management hasn't yet made a decision. And so by working together to come up with these cooperation agreements, we're calling them cooperation councils. By coming up with cooperation agreements on a pre-decisional basis, we can either obviate the need for formal bargaining post-decisionally, or we're at least limiting the number of issues left to negotiate in the traditional collective bargaining process. But by having the leadership interface directly and running the meetings jointly, rather than having the union go through a labor relations intermediary, which has not, and I'm being very generous in how I'm about to put this, has not been an effective or efficient way of getting the public's business done, shall we say, I hope is going to lead to greater benefit for the employees, greater benefit to the public in terms of improved public service. So we've already teed up several issues, such as a child care subsidy for lower income workers. That's something that we're going to tackle. We're going to tackle the future of training at SSA, because the training programs at SSA are abysmal and have been a major driver of our new hires leaving the agency, to provide better support to employees when they come out of training, they get proper mentoring and proper support when they're in the office, because our surveys and the emails that we've seen from employees who have left the agency within a year have all stated very consistently, I feel like I've been set up to fail. I'm not getting the support that I need. I don't know what I'm doing, frankly, because I haven't been provided the training and support that I need to understand these programs, which, I mean, a claims representative training class or specialist training class, that you're talking 3 to 4 months on just one of the two main programs that they're responsible for administering, whether it's retirement survivors and disability insurance or supplemental security income. These are very complex and technical programs that take months to train. Just on, the basic training, it takes 2, 3, 4, oftentimes 5 years to become proficient in these programs because of how technical they are. So, we're looking to sort of overhaul all of those things. And by doing so, again, to the extent possible in this cooperation process, where we can talk about interests and we can talk about what we need without having to worry about supposed violations of management rights and other types of pitfalls that would lead to disagreement and fighting. So we're hopeful that by having this new process in place, it will continue to yield further results that will benefit employees and the public alike.
Great. Well, brother, I really appreciate your time. That's great news, great background. I hope it's been educational for the audience. So looking forward to having you on again, and really excited about this for the 42,000 workers of the Social Security Administration across the country.
Thank you for having me, and please invite me back on anytime.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.